The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barquette, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
Good morning and welcome back to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury. I'm Matt Glenn, alongside Dan Grimm, as always. You can find us on the web at www.cbpw-law.com. You can also call the show at 573-708-7105. That's my voicemail. Leave me a voicemail, and we tape the show during the week. For security reasons, we don't like to tape it at the same time from week to week. But we will give you a call back, and if you have a question, we'll either get your question on the air or get you on with us to ask your question then. So, Dan, what are we talking about today?
So we're talking about depositions, and I think it's an important topic because almost every case that gets litigated, you're going to be doing depositions.
Yeah, anyone who comes into our office with a case, that is usually the biggest commitment that they have in terms of sort of effort and preparation. That is a deposition. They're extremely important. Party depositions, the depositions are the way that we find out what the other side is going to say in defense of their case and the way we convey our best case to the other side.
Right, because gone are the days of trial by ambush.
Right.
There's a long discovery process prior to trial. But part of the discovery process, usually the early part, is party depositions.
Right. And so when you're preparing a client for a deposition, how do you go about doing that?
So I have the client come in and we kind of just go through and we talk about things and things I think that normally, depending on the type of case, that I believe the opposing counsel is going to be asking about. And if we're talking about a standard motor vehicle crash, one of the things that constantly gets brought up is prior motor vehicle crashes.
Right.
And most clients kind of give you that look, and it's common because if somebody asked me, I'd probably be the same way. They don't remember everything. So part of the process is going through and remembering what took place 5, 10, 15, 20 years ago. We use some services. There's ISO services that can help search the database for prior motor vehicle claims. And the reason why I bring that up is that sometimes clients, maybe they don't want to, they're nervous about telling the whole truth, but what we always tell them, the other side is going to do the same thing. Yeah. They have ISO databases that they're going to run a file through your name, and if any claims you made in the past 5, 10, 20 years, it's going to pop up.
Yeah.
So there's nothing to hide, but we want to get it out so we can be transparent about any prior crashes or prior injuries.
Right. And I always tell my clients, look, we can fix anything except a lie. Right? If you start lying, well, first of all, I'm probably not going to represent you very much longer. But secondly, you'll really do irreparable harm to your case because so much of your case comes from your credibility. And if you lose that with the jury or with the other side, it's really hard to get it back. Every case has bad facts, right? Every case has some things about it that we as lawyers would want to change.
There's no perfect case.
It just doesn't exist.
No.
And so, we tell them, you give us your honest assessment of what happened, because many times at the beginning of a case, I don't know what our best legal argument is. And I've been to law school. So I don't expect my client to know what the best legal argument is either. So don't start trying to shape facts or make them look good or bad. That's my job, right? I make them look good or bad. All you need to do is just recite them.
Right. The facts are the facts. And another issue that gets brought up next to prior motor vehicle crashes, what we talked about, is prior injuries. Same thing. And when we come in and talk to clients, again, it's a process. And it's a process of getting to know the client, getting to know about their history, because I don't expect them to know every doctor or every injury, every treatment they ever treated for since their date of birth.
Right.
And so we go through that and talk about those things. But like you said, I mean, the idea is that we have to be transparent about that.
Yeah.
And it's a long process to where we kind of get into, like, as far as prior medical records, prior treatment, to figure out, did you injure your neck prior, injure your back prior? And a lot of people, like I said, they don't immediately remember, but through the process, gathering medical records, talking about prior injuries, everything will start coming back.
Right. And prior injuries are something that we deal with quite a bit in our practice. They're not the end of the world. I mean, if you treated 15 years ago with a chiropractor for back problems, and then for 15 years after that you were fine, that's pretty good evidence that whatever was wrong with you 15 years ago got fixed.
Right.
So don't be afraid to talk about, oh yeah, I really wrenched my back good back in, during the George W. Bush administration. And then you can deal with that fact and move on from it.
Yeah. No, that's exactly right. And so that's why part of it is having a conversation with the client well before the depositions. So all these things, as clients will see, they're not a big deal. They're
Right.
not a big deal.
Yeah.
Go ahead.
Many times it's also pointing out to the client what they may not think is important, but what actually is. I had a client one time who had a strange shoulder injury that you wouldn't think would happen in a rear end type collision. And so, we were kind of curious. I was curious and thought, the insurance company is going to look at this injury and say, well, it couldn't have happened in this rear end collision because it doesn't produce that type of force on the shoulder. Well, we found out from talking to our client that he was shifting his car into first gear. He had actually one of those old manual transmission cars, and he had pushed it into first gear, and his arm was still sort of locked and on that gearbox when the car behind him struck him. And so as his body went forward, his arm kind of stayed back, and that caused some ligament damage in parts of his shoulder. Well, he didn't think it was really necessarily a big deal where his arm was at the time of the accident, but the doctors that we talked to said it was absolutely a big deal. So we made sure that those questions got asked at his depot, and he was able to tell that part of his story, and that was able to help him, get a better settlement.
That's exactly it. I mean, and so part of the deposition prep will go through the facts of the collision. Mm-hmm. Where are you coming from? What were you doing? What was going on at the time of the crash, immediately before the crash and after the crash?
Yeah.
So like you said, as far as how long were you sitting at a stoplight? How was your body positioned? Where were you looking? Did you have your seatbelt on? All those things help the client remember what happened that day of the crash. And the biggest thing that I get clients that they feel they become overwhelmed, that they feel like they can't remember exactly what was going on, at the time. But I think that's why it's so important to kind of go through different steps with the clients to help them remember what happened.
What do you tell them about distance and time?
Distance and time is one of the things I tell them it's to the best recollection. As far as, well, what do you tell clients?
Well, for distance, maybe they can estimate, but amount of time, the amount of time between them entering the intersection and the other car hitting them, that's not something they measured, right? They didn't look at their watch and say, I'm entering the intersection in anticipation of getting in this car accident, and 1, 2, 3, bam, right? And then the impact happens. Invariably, what clients will do when they try to estimate time is they'll get it wrong. But when they swear under oath that it was 5 seconds, then you've got to live with that 5 seconds.
Right. Because they don't realize how long 5 seconds is. 1 Mississippi, long. 2 Mississippi. Right.
And there's plenty of time in there to react. And so I always tell them, I ask them, do you know how much time elapsed in between you coming to a stop and the impact? And they'll say, well, and I can see them start to reach for an answer, right? There's an instinct that people have to try to provide information. Well, it was probably about 4 seconds. And then I say, did you look at your watch? And they'll say no. I said, well, then don't swear under oath that it was 4 seconds, because you don't know. It is not, unless you know a fact, you shouldn't swear to a fact. And that's really one of the basics of depositions.
That's so true. And a lot of times, the client will ask, do you want me to guess? Do you want me to estimate?
Right.
Do you want me to guess? And opposing counsel is like, I don't want you to guess.
Right.
And because you're right, because people don't realize what distance is. Is it 30 feet, 100 feet?
Yeah.
Is it a second, 5 seconds? It's each case is a little bit different, but you're right. That advice is don't guess.
Yeah. So that's a lot about party depositions. If you're ever in a lawsuit, either as a plaintiff or a defendant, you probably will have to give a deposition. We didn't really talk about the nuts and bolts of them. You're basically in a room with your lawyer next to you, the opposing counsel asking you questions, and a court reporter somewhat magically writing down everything everyone says. I'm not entirely sure how they do that because they don't appear to have anything that looks useful to me. But they have a stenographic machine that they copy everything down. Other times you might actually be a witness to an occurrence, and you might have to provide witness testimony. And we see this a lot with family members of our clients and friends of our clients who may have seen the impact that an injury had on somebody, and they wind up being a witness who testifies.
Right. So, I mean, a lot of times part of your case is not only you testifying as far as how this injury has affected you as compared to before the crash, Some of your most credible witnesses are your boss, your coworkers, your neighbors, your friends, family members that see you on a day-to-day basis, week-to-week basis, or even a yearly basis. They can say how this injury has affected you as before as compared to after the crash.
Right.
And that's powerful testimony.
Yeah, it absolutely can be. And it's important when we sit down with these witnesses that we tell them first thing, we need you to be completely honest about this. If there's something, I don't want you to get in there and think you're going to advocate for your friend. That's not your role here. Your role is simply to answer truthfully. I can tell you that there have been several times where I've seen witnesses try to advocate for their client or for their mom, and they wind up getting the tree branch cut right out from under them. I had one son testifying on behalf of his mother who said, you know what, the carpet my mom tripped over, it was always looped. And I was defending the case at the time. I said, really, always looped? He goes, yeah, every single time it's looped. And I said, well, you've been to the store a dozen times, right? Yep. Every other time you're there with your mom, it's looped. Yep. Was it looped on that day? He said, yes. I said, well, you said you didn't go in. That must mean you must have parked facing the doors and looked through the doors at the looped carpet. That's exactly what I did. Right? And he really thinks he's winning it for his mom. And I said, so you looked in there, you saw the looped carpet, you knew your mom, who's 83 years old, was going to walk into that door. Did you say, hey, Mom, look out for the looped carpet? And there's dead silence because he can't say yes, because then why didn't she see it? But you can't say no because that doesn't look good either. So he went with no, and I said, why not? And he goes, I guess I had a lot on my mind. And that was the end of that testimony. And that witness in his effort to try to make facts look good really, really hurt his mom's case.
No, the facts are facts. That's what we always say. And your job is not to advocate.
No.
It's just tell the facts as they are, as you see them, because that's all you're there to do.
Right.
That's all you're there to do.
It's especially true in a premises case. If you're ever near a premises case or somebody slips and falls at a big box store or at a convenience store or really anywhere, turn into a historian. Write down what you see. Note what you see. Give your information to the manager. Have them write down your name and telephone number, or if it's a close friend or family member, maybe snap a photo or two of the area. Turn into a historian, because people, I see more witnesses come in and say, there was always snow right at this particular part of the parking lot. Every time it snows right on this part of the sidewalk, they never get it shoveled correctly, and it's always there. And I mean, we've seen it probably 10 or 12 times where there's snow there. I'm like, okay, well, 10 or 12 times, why did you navigated it 10 times before, why not this time? So turn into the historian, write everything down, then let the lawyer figure out what facts to highlight and how. Right,
and that happens so often where a crash happens or something happens, a slip and fall at a store, that people don't even think about getting witness names, getting witness phone numbers. Yeah. Like you said, becoming a historian. And then later on, they say, "Oh, that one person was there. Did you get a name? No. Did you get a phone number? No."
Right.
So you're right. It's so important to get names, phone numbers, contact information, and who saw what.
Yeah, and that I used to give the same advice to my defense clients, the convenience stores I represented up in St. Louis. That fall happens, document everything. And I had one set of convenience stores that were really great at it. I could tell you everyone who bought gas at that convenience store within 30 minutes before and 30 minutes after the incident, because they had security cameras to fight drive-offs, take photos of license plates. So we could find these people if we need to. The more information you can give your attorney, the better chance of success you have.
Yeah, and nowadays it's with especially a lot of businesses. If a crash happens on a busy thoroughfare, what we're seeing is a lot of businesses have surveillance cameras that will catch what happened out on the roadway.
Yeah.
So that's sometimes your best witness ever.
The very little that is not videotaped out there.
Right.
So behave accordingly, especially if you're planning on running for office. So that does it for segment one of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury. For Dan Graham, I'm Matt Glenn. Stick around. We're back in a few minutes.
Cook, Barquette, Ponder, and Wolves are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And welcome back to segment two of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury. Alongside Dan Graham, I'm Matt Glenn. You can find us on the web at www.cbpw-law.com Or you can call the show. My voicemail, 573-708-7105. Leave us a message. We'll get your question on the air, or maybe we'll put you on the air and make you famous in front of dozens of our family members. So today we've been talking about the importance of depositions in personal injury cases. We spoke a little about party depos, what we do to get our clients ready for those, witness depositions, how we talk to witnesses and make sure they're able to give accurate accounts of what happened to their friend or loved one. There are other types of depots. One of them is a corporate representative depot. Dan, tell the folks at home what a corporate representative depot is.
Yeah, so on your standard auto and auto, you won't have typically a corporate rep depot. Where you see that at is commercial motor vehicles. For example, like trucking cases. A corporate rep in a trucking case would be someone that's speaking on behalf of the corporation. Mm-hmm. And what we're typically seeing with those type of depositions gets into like training and hiring and supervision of the drivers, of the commercial motor vehicle drivers. And that's what we're looking for as far as, how they go about training them, what kind of supervision they have, as far as the health and medical care of their drivers. So those are the type of things you're looking with corporate rep depots. Now, for example, like in premises liability cases, you're looking at store managers. Right. Would be somebody who could be a corporate rep. And also in first-party cases, which would be if a lawsuit is being brought against your own insurance company for what's called a breach of contract or a vexatious refusal to pay, you could take depositions of the insurance company corporate rep or managers or adjusters. Right.
Yeah, you're right. They come up almost exclusively in a corporate type of setting for a corporate rep. Premises cases, I always think this is where the case is won or lost. If the corporate rep designee is really on top of their training and they're able to answer questions about everything they did to prepare their employees for this moment, everything they did to prevent a spill from happening, everything they did to correct the spill as soon as it happened, those can be really effective. I took a corporate rep depot once of a store manager, and as he walked around his store looking for potential hazards, he had put barcodes in each aisle. And when he walked by the barcode, he would scan it with a price gun. And it would document that he was there and what time he was there. And so his attorneys were able to put him in an aisle where a fall occurred 3 minutes before the fall happened. And he was able to say, I was there, I can document I was there, and I can tell you there was nothing wrong with the aisle. That can be powerful information. Contrast that with some store managers I've taken their deposition and they talk in glowing terms about all the training they do and all of the focus on safety and how important it is for all of their employees to be really focused on customer safety while they shop at their store. And then you show them videotape of their employees being concerned about everything but safety and walking by a puddle. I had 20 employees walk by a puddle within 10 minutes of the fall. And not one of them looked over at it. Not one of them went over and put a wet floor sign down. Not one of them took the steps they needed. Those can really cut both ways.
And that's the reason why the corporate rep depot is important, because typically what you're trying to show is that these corporations are putting profits over people's safety. Yeah. And a lot of times that really cuts, as you talked about, is where it's a lack of training, a lack of supervision, and quite honestly, inappropriate hiring. There are certain people that should not be working at certain jobs.
Yeah, well, and many times these store managers are getting a lot of pressure from the people that own the business. Hey, we need you to sell more. We need you to push more items out the door. We need you to sell this particular item. We need you to be drawing customers' attention. It's because we have way too much ketchup or something. So you put a big flashy sign up saying, come in and buy this ketchup right now. And the customers are drawn to that sign. They're meant to be drawn to that sign. And what are they looking at? They're looking at the product on the shelf. I always say in a premises case, you've heard me say it before, you walk into a grocery store or a big box retail store, and there's quite a lot in there that is for sale. But the one thing that I've never seen for sale is the floor.
That's right. That's right.
And so they don't want you looking anywhere except the items that you might want to buy. And that's why they're constantly drawing your eyes to them. Well, if they're going to do that, and they should, they need to make sure that there's not something on the floor that's going to cause one of their customers to fall.
Sure. And you look at the grocery carts from the last 30 years, they keep getting bigger and bigger and bigger because they want you to keep putting more and more stuff in it to buy.
And the aisles getting narrower and narrower.
Right. But no, that's where, like you said, and a lot of times it's, even though the individual employee or the individual driver clearly did something negligent, a lot of this stems through the corporate culture or the lack of safety through the corporate culture.
Yeah.
And that's the purpose of the corporate rep depot is that this is not just an isolated situation. This is systemic.
Right. Yeah. Well, you and I had that trucking case together before we even joined forces as partners, where the corporate rep said, "Oh no, we're fine with our truck drivers exceeding or going 75 miles an hour." Not even exceeding by 5 miles an hour. We're fine with them going 75. And that apparently, according to the truck drivers, was true if they were in a 60 mile an hour speed zone. Well, it's not safe to drive a multi-ton semi-tractor trailer 15 miles an hour above the speed limit that other cars are going, around you. It's just not.
No, but their motivation is to get the products from point A to point B because a lot of these trucking companies are paid by the shipment.
Yeah. Yeah.
The quicker it gets there, the more money they make.
Absolutely. Corporate rep depots, that's another type of depot you can run into in your lawsuit. Also, expert witnesses. We see these an awful lot in products liability cases. We see them a fair amount in car accident cases. Tell the folks briefly, Dan, what's an expert witness depot like?
Yeah, so an expert witness is somebody that is specialized in an area. And often what you see is like in motor vehicle crashes, you'll have an accident reconstructionist that can come in and lay out exactly how the crash occurred. Because obviously you as an injured victim are not an expert in that area. You're in the car, but you're not an expert to articulate what exactly happened. You can see it as far as in the injury cases. Your treating doctors are somebody that can testify on your behalf, but you may have a medical doctor that's an expert in a certain field that will talk about something on top of what your doctors may talk about.
Right.
As far as you mentioned products liabilities, that's heavy in expert witnesses. In medical malpractice as well.
Oh, yeah. Oh, absolutely. And when you talk about accident reconstruction, here's one area where the world is a safer place because of injury litigation. When we were kids and you looked at a semi-truck, it would have lights all over it, have lights on every corner of the trailer, tail lights, 2 or 3 of them many times, maybe a light around the license plate. Those things were lit up like Christmas trees. But when I was growing up, they didn't have that strip of what they call retroreflective tape. And now, if you'll notice, you take a look at any trailer out there on the sides and on the back, there is this retroreflective tape. And I talked to an accident reconstructionist once, and he talked me through why that was. And he said the lights, you can't judge depth-wise how far away the lights are from you. So when the trucks just had taillights, they could be stopped, and it would look to a motorist approaching it like it was still moving. Mm-hmm. But retroreflective tape, that tape actually bounces the light back to you in such a way that you register, hey, that thing isn't moving as fast as I am. And for years, people were smashing into the back of parked semi-trucks and getting very seriously injured until they started requiring them, hey, put this retroreflective tape on there. And the accident reconstructionist we used in one particular case, he had a video of it where it showed a motorist at night approaching a truck that had all its lights on, and man, you could not tell that truck was stopped. They tried it again with the retroreflective tape on it, and it was easy to see. It made all the difference in the world.
Sure, and you'll see that with the commercial motor vehicle regulations, that you'll have an expert talk about why these safety features are important.
Yeah.
Because the average person just doesn't know.
No, they save lives. Now, it's something you can look at. Next time you see a truck out on the road, take a look for that retroreflective tape. The odds are really, really good you're going to see it there, and that makes it safer. You're right. We see it a lot in terms of products liability. Many of the lockout, tagout methods that people have when they work in a factory, where you basically lock the switch up so it can't be turned on, so then you can step in and clean these implements that spin. I know that a lot of food processing plants have things that help clean the animals. Well, they got a lot of moving parts, and if your hand gets in one, you're going to lose your hand. So they have, the experts talk about how you can take something as inherently dangerous as cleaning something used to gut a chicken and make it safe. Design it in such a way that it can be safe. And that's something really industrial engineers know that the average juror doesn't. And so it's through an expert witness deposition that they kind of educate the jury on, hey, this is why this product isn't safe. This is how it could be made safe. And this is what they should have been doing.
And these experts can look at, the last 10, 20, 30 years, how things become safer and safer and safer through certain mechanisms or regulations that really help keep the average person safe.
Yeah, well, it's better design. And we talked briefly about the Corvair, which Ralph Nader said was unsafe at any speed. It was unsafe because it had a solid steering column that went from the steering wheel down to the axle. 15 mile an hour front impact, that steering column was going through the chest of the driver, right? That's just not safe. But shortly after the 1960s, they actually came up with a design where a front impact would cause that steering column to break into 3 pieces, and then it wouldn't come through the chest of the driver. Right? That's a better design that an engineer came up with, and once they came up with that design, it became the responsibility of every car manufacturer to use it, right? To make your car safe at a 15 mile an hour impact.
And that's the purpose of the expert deposition or expert testimony at trial, is that he can explain to the jurors that would not have any way of understanding it otherwise.
Yeah. So another type of depo we get a lot of in injury cases, obviously, are doctors' depositions. We're not doctors. None of the jurors are doctors. Very, very few of our clients are doctors. They have to rely on physicians to connect the accident to the injuries that they're going through. What are some of the things about doctors' depots you've noticed over the years?
Well, I mean, it's one of those things that doctors are. It's important to when you take your doctor's depot that he has all the records in front of him.
Right.
Because when you do a doctor's depot, take it for a motor vehicle crash. The doctor needs to know the whole history of the patient.
Right.
The prior history, the current history, so that way he can provide what's called causation.
Yep.
He's going to provide causation as to how this injury occurred, that these injuries stem from this crash.
Yeah.
And then also, as far as a doctor, he's going to talk about as far as not only what the client went through or the patient went through since the crash, but as far as future medical care, future needs, future limitations as well.
Yeah.
And the doctor is a key person in being able to testify what this person's going through, not only presently but into the future.
Yeah, and that's really a large part of the case. We get so many people that I know just in my life who say, ever since that car accident, I just can't, just not the same. I can't walk as much, I can't garden as much, and they're dealing with those symptoms. A good doctor will tell them not only this is how you get better now, but this is what you need to do to be better in the future. And these are the steps you need to take. And you know what? You need to be watching out for arthritis in your knee. Right? You need to watch out for this symptom in your neck because you're at increased risk for that. Medicine can be somewhat unpredictable. We don't know how people will heal. But in a lawsuit, we get one chance to get paid for everything, not only that's wrong with them now, but that could develop in the future. So you're right. A doctor testifying, this is what you're at increased risk for, that's huge.
Sure.
In our field.
And some people may think, well, gosh, I'm the injured victim. I can talk about these things to the jury, and you can talk about what you're going through, how it's affecting you as a person. But as far as medically speaking, you have to have a doctor talk about that because you just don't have the qualifications.
Well, you can't necessarily tie it into the accident, and you can never. It's never allowed for a plaintiff to testify that they're going to feel this pain in the future. Right? That's something that a doctor has to use his or her expertise in to educate a jury of, hey, this. I've seen this injury before, and in the vast majority of patients that I treat, it does not go away.
Sure. So pretty much every case you have to have some type of doctor testimony.
You do, and that's one of the things we do that's kind of expensive. We have to pay $3,000-$4,000 for a doctor to give testimony, and those are part of the risk that we run when we file a lawsuit. We're spending that money hoping we'll get it back. Okay.
No, and it's these average lawsuits. What do you think you've seen as far as the cost of an average lawsuit?
It ranges from a few $1,000s. Our record is well over $200,000 that we spent just to get a case in front of a jury. Thank goodness we won that one. But we've had them 6 figures where it didn't go our way, and that's just one of those things that when you're going to fight the fights we fight, sometimes you're not going to win.
Right.
There have been trials where I have in fact finished in second place. Yeah.
The first loser.
The first loser. They get paid as much as the last loser. So, that'll do it for this edition of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Dan Grimm and everyone at Cook, Marquette, Ponder, and Moles, I'm Matt Glenn. We'll see you in a week.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.